I think the time we've got enough members here for a quorum. At this time, I'm going to call this meeting to order. If there's anyone out there, if you've got your cell phones, cut them to silent. If not, there's a $100 fine to some charity. All right, first up today, we've got Senate Bill 270. Mr. P.K. Martin and Representative Chairman Jaspers is going to be handling that bill.
Mr. Chairman, thanks for allowing me to carry this for Senator Martin, who's in another committee like many of our committee members are right now. 270 is a combination of the original 270 and a few items out of 1060 that we passed out of the committee earlier. Section 1 is Senator Raffensperger's bill, and I will turn it over to him. It was House Bill 790, which we looked at earlier.
Thank you, Mr. Chairman. HB 790 was a bill that was came through, made it to the rules. That would increase the penalties for swatting. And so a lot of people say, what is swatting? Swatting is making a hoax 911 call, but it's really taking a hoax 911 call to a whole different level. As we saw just over this past weekend, there was a swatting incident in Fairburn. Typically what happens is someone disguises where they're calling from, so you think it's this person's house, but it's not. It could be a state away or 200 miles away. SWAT descends, then people can be harmed. So in going through, working with Representative Hightower, Chairman Golick, B.J. Pack, and also other representatives, what we did is we looked at the existing law, and then we increased the penalties for a second and a third offense. Now, actually, based on Representative Hightower's experience, he actually would, for a first-time offense, we actually lowered that from a felony as it is right now to a high and aggravated misdemeanor. They just felt that if little Johnny, if there wasn't an innocent little kid that didn't really understand the full significance of what he was doing, that actually instead of facing a felony, it would be a high and aggravated misdemeanor. But then if it happened the second time, that's obviously not a little Johnny, doesn't know what he's doing. That then would be stepped up to a 5 and potentially a 10-year. The 10-year potential jail sentence or prison time would be based on if it was critical infrastructure. We also increased the financial penalties. Also, at the pleasure of the committee, we put in line 66 to 66 to 71, and at the pleasure of the committee, I would like to ask if those could be removed. We got some feedback from Senator P.K. Martin and also the Sheriff's Association, and they just preferred that that would not be in the final bill, and I'm fine with that, sir. Line 66 to line.
It's Section 1.
Yeah, we're in Section 1.
Any questions from the committee?
Mr. Chairman, Representative Raffensperger, what was the, you were describing this as, what did you describe this as?
Is swatting.
Swatting?
Swatting.
Swatting.
Yes, as in
Okay.
SWAT, the SWAT team.
Okay,
So
swatting.
the term that's been used is swatting. This actually came as a request from Detective Sergeant Ben Finley of the Johns Creek Police Department. In January 2014, while I was still on City Council in the city of Johns Creek, there was an incident in Country Club of the South. So a call was made into the Alpharetta 911 call center that this person said that they had killed their wife and they're holding their kids hostage and they wanted $30,000. The owner of the home was flying in from Atlanta. The wife was not there, and what they found were 2 kids and a nanny that were terrified when the SWAT showed up. So that's what then led Detective Sergeant Finley to do his research, and it was very difficult to find the SWATter because what they do is they bounce off of different internet relay stations, and so they finally hunted him down on that situation. So that's why I brought the bill. And Detective Sergeant Finley spoke to the hearing that we had in Judicial Non-Civil, the BJ-PAC subcommittee, and along with Chief Ed Densmore spoke to that, and along with the mayor, Mayor Mike Bodker, who's also this year's president of the GMA.
And do you have any information about how frequent these types of situations occur?
Well, line 66 to 71, which were asked to be taken out, if they were taken out,
Required reporting.
that had the required reporting. What we do know is it does happen. In fact, it just happened this past weekend in Fairburn. So
really?
it's something that happens, and it's just happening with more frequency.
Gotcha. Thank you.
Yes, sir. Thank you, Mr. Chairman. I have a question in regard to line number 49 down to 54. First of all, how old does little Johnny have to be
Well, if he's
when he makes that phone call, and because of something probably that he's seen on television, and it becomes a higher and aggravated misdemeanor? How old is little Johnny or little Betsy have to be? Because we have, in the past, I've heard of young teenagers making these calls.
this would be age of majority.
Excuse me?
Age of majority. Otherwise, he'd be in juvenile justice. 17? I believe it'd be
Is
17.
that
17.
Okay. Thank you.
Ms. Frazier, that answer your question? All right. Any other questions of the committee? Mr. Jaspers, you want to carry through the rest of the bill?
Sure. Thank you, Mr. Chairman. In Section 2, these are from 1060. We saw quite a while back. They're just trying to get these in. These are things we think were important from 1060. The nature of time during this is, I believe, day 37. We decided to add this to this. And it is P.K. Martin's bill, and we'll talk about it as we go through. In Section 2, we're talking about those folks who move here and within that 90 days allow them to use their weapons license according to Georgia law. That was one thing that came up out of the discussion. They're not being able to use their state's law. They have to use our law while getting that license, and gives them that 90 days. On line 98, we're talking about the hunt and fishing license we talked about earlier. Section 3 is the church. When someone's asked to leave, they leave immediately. That's fine. If they don't, there's the penalty that's there with it. Section 4 is gun safety. I think we've all recognized that this was something that was needed, and Chairman Powell put it very clearly on the House floor. It's come from a lot of our members and some of our minority members that this was important, and we're glad to put it in there. This is a good start, putting safety in. Section 5 is Senator Martin's part, and essentially, it was in our 1060 also, and this is letting those folks who are retired from out-of-state law enforcement come to Georgia and carry throughout our state. But what we did with counsel and then smartness really tightened it up from what has been thrown out there to us. Making those people that have been 10 years in other states and they're separated with good service. They have an identification card. They're going to be post-certified, and it's including, but not limited to, the maintenance of a firearms training, which is a real strengthening of what they passed in the Senate. 6 is the airport. We're just trying to make sure that we clarify that if TSA is present at the airport, they can and they will stop firearms past TSA, but in the front of TSA, it's okay, just like it is in the Atlanta airport. Section 7 is one of those neat things that's in this bill. That's why we really want to add this. This provides protection from those men and women who provide training in our state to our citizens in firearm use. And it just protects them from civil liability. And just like I'd like to tell people in the short, if I train you and you go do something dumb, they can't come back after me because you're acting as an adult with your own brain. But Mr. Chairman, those are the additions we made, and I'd be glad to answer any questions.
All right, I'm sure there are some. Mr. Petrie.
Yes, sir. We went kind of quickly through there. I just wanted to ask quickly about in Section 2, could you explain a little further about hunting license, hunting and fishing licenses?
Okay, just like
So
what it says here, if you, any person with a valid hunting or fishing license not required by law, that's that kind of, then we skip all this other, may have or carry on his person a knife without a valid weapons carry permit. And this is one of these crazy things that happens, Representative, where a DNR agent cited someone with a knife while fishing, and we're saying that ain't, no, you don't have, you can't do that.
You got to be kidding me. That's
I'm
I'm
sorry.
trying to understand why it's necessary to do this, and I think you just told me.
Well, I shut my eyes and shake my head and agree. But we had to do this, and there was no opposition
Okay.
from DNR for doing this. There's not. They
would hope
wanted-
not.
So I'm sorry. I
Gotcha.
say, I'm sorry it's in there.
I just was surprised. Okay. Got you. Thank you.
Yes, sir.
Thank you, sir.
Any other questions of the committee? Ms. Frazier, did you want to make a? Did you want to ask again about the 90 days?
No, sir.
All right. Does anyone wish to be heard on Senate Bill 270? Mr. Robert Quigley had signed up. Yeah, very good. All right. Does anyone else wish to be heard? Any committee member have any other questions? If not, what's the will of the committee? We have a motion. We have a second. We have a second. You have before you LC 410812S. Is that correct? Is that what everybody has? Any further questions? No
Mr.
other
Chairman.
action?
I'd like to make an amendment, Mr. Chairman.
All right.
I move that we strike lines 66 through 71, section 1E, that entire section.
On line 66 through 71.
Yes, sir.
Great. Yeah,
All right. Do we have any questions? All right, we have a motion. Do we have a second to the motion? We have a second. Any further questions about that? All right, so the posture would be we would need to pass. We have a motion on the bill and a second. So let us start with the amendment. We have an amendment to strike line 66 through 67. All in favor say aye. Aye. Opposed? Ayes have it. We return to the full substitute to Senate Bill 270, and we'll do this as a committee substitute. All in favor say aye.
Aye.
Opposed? Let's have a show of hands. All in favor? 2, 3, 4, 5. Opposed? 1, 2, 3. The ayes have it. This bill's on the way.
Thank you, committee.
Thank you, Chairman Jaspers. Did Mr. Kennedy, has Senator Kennedy come yet? Would somebody stick?
Might be outside.
Mm-hmm. Welcome, Senator.
Good afternoon, Mr. Chairman.
Good to have you here.
Thank you. Glad to be
All
here.
right. Call up Senate Bill 332.
Good afternoon, Mr. Chairman and the committee. This is a Senate Bill 332 is a bill that would, is this on, Mr. Chairman? It is? Okay, thank you. Is a bill that addresses a problem that judges have in the state right now, which is that there is no state-issued photo ID for judges in Georgia. What they have is a small piece of paper that we have, which is from the Secretary of State's office. It says their name - judge. And this can be a problem in a couple of different instances. Number one, it can be a problem where a judge is outside his or her home circuit. If they're in their home circuit and where they're usually known, it's not a real problem. But when they travel outside their circuit and they try to get through the security, sometimes they can be forced to go through security, and that can delay. If you're in an area of high traffic and they get delayed up, that can delay court. Secondly, one of the better examples, actually, and I would have to tell you that this information came during the course of one of the hearings afterwards. One of the Superior Court judges that heard the presentation of the bill said, "I'm so glad and appreciative that you're doing this, because I spent an hour and a half 2 months ago trying to get into a prison facility because I was supposed to go in and preside, and I had nothing on me that said I was the judge." And notwithstanding telling the bailiff or the person operating the metal detector and trying to convince him I was a judge, I had nothing that showed that until they made multiple phone calls, and an hour and a half later came back and said, "Yeah, well, apparently you are the judge." So that's really what the bill does. It provides for a state-issued photo ID for judges that they can use, that won't be just only for their convenience, but also be for purposes of, we think, allowing the efficient administration of them being able to do what they're due, especially when they're outside their own judicial circuit. Should not be any fiscal impact. The cost of this is going to be about $7 per ID, and that'll be paid for by the judges. So no cost to the state.
All right. Any questions? Mr. Glenn.
Thank you, Mr. Chairman. 19.
Yeah, I've got it on.
That's too far away. Okay. Anyway, and I think you answered the first part of my question, Senator, and that was the cost. And so the cost would actually be to the individual as far as the physical impact here. 2 questions. What's the duration of the initial license? How long? And what if a judge? I mean, using as an example in the legislature, some of us are here and some of us don't come back. Sometimes judges sit and sometimes they don't. So, what kind of mechanism would we have in place to make sure that those IDs are turned back in as you would anything else that's issued, excuse me, to law enforcement? How would we police that?
Yes, sir. Good question, Mr. Representative. And I'm looking for the language, but it is a duration of 4 years, which would be for the judicial term, so that the term of the ID should match the term of the judge. And so they will have to renew these just as they are reelected and re-sworn in as judges.
Follow up, Mr. Chairman.
Sure.
And thank you for that answer. I guess part of what I'm looking for is if a judge was prematurely unseated. Of course, the duration of the license is going to coincide with the term of the judge. But what if one is prematurely steps down or gets sick or whatever the case may be? What mechanism in this particular bill do we have to ensure that those licenses are in fact either turned back in, destroyed, or what are we, because if you're talking about access to prisons and institutions, that's a very serious matter.
Yes, sir, and I'm trying to remember, Mr. Representative. I don't believe we have a mechanism for destroying them, but the card itself will have an expiration date, if you will. So I think that answers the second question. But as to your first question, if you had a judge that was removed from office, I don't think this bill addresses that particular portion. I'm looking through it. I know that Section C, and forgive me, my pagination is off with the copy that I have, but subsection C of 1556 or 15536 says every personal identification. Pardon? Well, my line is off. I'm sorry. The copy that I have. It's right below the bold all cap letters space. The 3 paragraphs below that, beginning with C, it says every personal identification card issued under this article should be valid for a period of 4 years and shall be renewable for as long as such person meets the qualifications of paragraph 12, 12.1, and 12.2 provided. However, that upon such person becoming a former judge or justice, he or she shall surrender a personal identification card that designates him or her as a judge or justice and may submit an application for personal identification card which reflect his or her status as a former judge or justice. So that actually would address your question.
Thank you, Senator.
Yes, sir. Thank you for the question.
All right, any other questions? Do we have some folks signed up for 332? I have a Robert. Mr. Quigley, you want to speak?
Mr. Chairman, you want me to stay here or step back?
Oh, I think you need to stay. They can go to the podium, Senator.
Oh, okay. Thank you.
Thank you, Mr. Chairman. Here, I'm Robert Quigley with the Cobb County Sheriff's Office, representing the the Georgia Sheriff's Association. The substitute to 332 is great. A lot of good things happening in there. Thank you very much for taking into consideration our concerns there. I do note on line 312, it addresses allowing uniform law
Quigley, and we're back to the original bill. The substitute was not considered.
I guess I better pay attention.
I'd be glad to give you a copy, and you can look it over real quick.
I'll get just a minute from you.
Yeah, if you would just.
Okay, thanks.
If you would step over here. Let's see. Yes, ma'am. Would you like to step up and identify yourself?
Thank you. Ashley Garner, Chief Budget Officer for the Judicial Council of Georgia. Fiscal note was provided to the Governor's Office of Planning and Budget and the Department of Audits and Accounts, and the total impact on our agency will be $28,000 to develop the system required to generate the identification cards. There are quite a few requirements within the bill for overt and covert security measures. So that information was provided several weeks ago.
Really?
Yes, sir.
Any questions of the committee members? Any questions? All right. Do we have anyone else who wishes to be heard on this matter? No? Everybody's scared of Superior Court judges, aren't they? If I might ask a question, Senator. Superior Court judges, once elected, they're given an ID card, aren't they? Or maybe the lady back here would be the better one to ask that question.
Be glad to let her, Mr. Chairman. My understanding is not a photo-issued ID card.
Judges don't have a photo-issue ID card?
Some of our lower court judges do not. The executive director from the Council of Superior Court Judges is here and may be able to speak directly to that.
Well, let's see if we can't get that person up here. No need in hiding back there. Would that be the lady that's talking to the former senator and now the judge?
Mr. Chairman, the reason I'm talking to her is I'm trying to get the answer.
Well, you know, Your Honor, there's some things never change. The product of the Senate is still just the same.
Welcome, Bill.
Thank you.
As I understand it, judges are not issued a photo ID, and frankly, I have a badge that I was issued, but I'm not sure all judges are issued badges. But there's no photo identification with my badge. I've never tried to use it to basically show that that judges are currently by law allowed to carry weapons, but this was just an effort to make it obvious. So I guess my answer is some judges have badges. As far as I know, judges do not have photo IDs, and they certainly don't have anything that shows that the law allows them to carry weapons. Unless you could say a badge allows for that.
All right.
It's the best
Mr.
answer
Clanton.
I can give, I think.
Thank you, Mr. Chairman. My question is, you brought the point about the badge, and now we have an ID. Will the badge and ID, or will the ID have the badge number on it, or something that?
And I'll certainly defer to the judge with regard to what the procedures are for Superior Court judges, but a couple of points if I could make in answering your question. First of all, I'm not aware of any uniformly issued badges to judges. I am aware that some judges have badges, but I think that is a matter of something that they get from perhaps locally from their sheriff or somewhere within their circuit, and I don't believe it's state issued. I would like the judge to correct me if I'm wrong, of course. Secondly, in furtherance to his answer, to supplement that, I have worked with the judges who are on the Council of Superior Court, the officers of the Council of Superior Court Judges, and I think if there were something already uniformly issued by the state, it certainly should have surfaced before now. I would hope so, given the work that I put into this bill to try to help them so they do have a state-issued ID. I think lastly, your question was linking the number on the badge with an ID. I think that's problematical because I don't think there is a state-issued or even necessarily a uniformly circuit-by-circuit issued badge to judges, nor is there to my knowledge, again, that's the whole purpose of the bill, a uniformly issued, state-issued photo ID for judges.
And I do agree with you that it would be problematic if it's not consistent across the board.
Yes, sir.
Thank you, Judge. Any other questions by any of the other members of the committee? May I ask you if I might ask a question? I mean, it sort of stuns me to know that how many Superior Court judges, well, how many judges do we have to be affected by this? $28,000 seems to be some pretty high price to be issuing a ID card. Have y'all got, lady, come on back up here, please.
With approximately 1,100 judges in Georgia, it's only estimated that approximately 500 would take advantage of this opportunity. It would be voluntary, but a system has to be developed, whatever agency this is housed at, whether it was DDS, the Judicial Council, AOC. A case management system has to be developed to obtain the information and then transmit it to a vendor who, at a cost of I think $14 a card, would be able to generate the identification.
At some point, Mr. Chairman, could I address that issue?
This would be the proper time to address it.
Yes, sir. Thank you. A little history on this. When I had initially drafted the bill, the idea was that the Administrative Office of Courts would administer it and that the ID would actually be issued by Department of Driver Services. That came back with an estimate of $130,000 to set up the template for this. I said, well, that's not going to work. So we then started looking for other ways to do this. Learned that there's a company in Vidalia, Georgia, that prints a lot of the badges or these photo-issued IDs for the probate courts and some other courts and has other state contracts. They came back with the estimate of $7 per badge. And then I asked for the fiscal note, and it was $28,000 for Administrative Office of Courts to handle this and the front money that was needed. Not being pleased with that because of the cost, we went back, and with the folks that I was working with through the Council of Superior Court Judges, they went back and approached the probate judges, who decided that they would do it at their cost, which is so no administrative upfront cost, and it would be $7 per badge and that per ID, and that would be the total cost. I was looking back through this one, Mr. Chairman, through the bill to see, and I suppose we do have, and forgive me, I'm assuming we're working from the latest version of this, and that change perhaps was made after this was passed, but the current plan is for the Administrative Office of Courts not to be involved with this from a financial standpoint. And there is no, the fiscal note that I obtained on that for $28,000 is not applicable. And the probate courts offer to do this for no cost, with the exception of the $7 per ID. And that's why I answered the question and addressed this committee and said that there would be no cost to the state. And I don't know if that's not been communicated sufficiently back to AOC. It was my understanding through the people that were working with this bill with me that had been communicated and that AOC was fine not to be involved. It was less work for them, and it took them out of the picture from a financial standpoint.
Yes, sir. We just had not seen an LC version.
Let's see if Mr. Petrie can add a little bit to this.
Yes, sir. Thank you, Senator. I was trying to understand. So this whole issue with the Administrative Office of Courts is not an issue. You're planning on going another route. So I was sitting here thinking about, and you mentioned probate courts. So a concealed carry permit is essentially what you're describing. I mean, it's a photo ID, it's laminated, aren't most counties creating these? I mean, we're producing a lot of concealed carry permits, and that's a pretty nice card, similar to what you're looking for, right? It's not a concealed carry permit, but I'm talking about if you just need an ID. But aren't counties already producing these everywhere? I know we are in my county.
When you say these, Representative, you mean concealed carry permit IDs?
IDs.
I suppose
I'm talking about the IDs that we're generating in all these counties anyway. Are we not?
I suppose, I guess that would be a different ID that's already being produced.
I'm talking about it's a different ID, but it seems like everything's there to produce an ID. I don't know how much more difficult it would be to do this. But if the court in a given county is already producing a large volume of these IDs, I'm trying to get a handle on the cost of producing these, and why we can't do it locally as well, by the way. I'm speaking to the cost and also to maybe doing these locally. Well, so if we want our judges in Chatham County to have ID cards, it seems like it'd be, I mean, I've never thought about it before until it came up. It seems like it'd be a pretty easy thing for us to do because we're already producing all of these other IDs for concealed carry permits and otherwise.
Yeah, Representative, I can't speak to how the concealed carry permits are handled and who produces those and if they're produced on a county-by-county or probate-court basis.
Okay.
But the concept here, and my understanding is that the company that's located in Vidalia would produce these.
Vidalia. And
they have contracts with the state to produce other IDs for other state agencies.
Okay.
And my understanding is they have that's where the probate court produces them. I don't think.
Okay, maybe where they're producing these.
That's why I don't know enough about the concealed carry permits. I don't know how those IDs are produced, but
Could I ask a question? Mr. Chairman, is there anyone in the room that may know where our concealed carry permits are produced for our different counties? Is there anyone here that might know that? Perhaps it's the same organization. Is there anyone that can speak to that?
I'll probably get this question right for you. Robert Quigley with Cobb County. What happens there is that the application is made locally to the probate court in the county.
Right.
And then once the application is made, Sheriff's Office put out with the task of having to go back and do a background check, reporting back to the probate court.
Right.
Probate court then moves forward with issuing the license if there's no issue there.
And the actual and the ID is produced where?
The probate court actually physically produces. They take the photograph and physically produce the ID. Then they mail it to the
okay, well, that's where I was going. So each local county is doing that themselves.
Yes, sir.
Okay, gotcha.
If I might ask a question, Senator, I'm looking on line 134 to 137. It says the administrative office of the court shall collect a fee as determined by the Judicial Council for any issuance of a personal ID card under this article, provided, however, that such fee shall not be less than the cost to the AOC for producing. I'm reading that it's basically going to be, the cost is going to be on the judges.
Yes, sir.
To the lady at the AOC, can the legislature feel confident that y'all are actually going to charge these judges the actual cost? Or is this going to be another pro bono deal?
The actual cost, with if there is no upfront appropriation, would be near $70 a card. Without that, the cost is near $14 per card. So if we get the $28,000 up front for the case management system that handles all of this, then the cost is $14 a card. If we do not, then it has to be calculated in so that the agency does not lose money. We cannot charge less than it costs us to perform this task.
So you're saying that there needs to be a $28,000 appropriations?
Yes, sir.
To y'all?
If it's the desire of this committee for us to perform this task, yes, sir.
Really?
Yes, sir, please.
And then if you get that, what if you don't get the appropriation?
Then it's an unfunded mandate, sir. And we would have to assess approximately $70 per ID card to the judges as they apply.
I think that's the tone of the language, that if the judges want them and they're willing to pay, then that's what they would pay.
Yes, sir.
Senator, is that your desire?
That the judges pay for them, yes, sir. And the concept and intent of this was that there be no cost to the state. And
so if I'm understanding what the lady from the AOC is saying, because I surely to God the General Assembly is not going to appropriate $28,000 for them to produce cards for judges.
No, sir.
Not that I don't think my judges don't deserve it. They carry weapons anyway.
Yes, sir. I think my judges are deserving as well, Mr. Chairman, but we're not asking for that.
But, I mean, I'm reading that very clear, and the process would be very straightforward. It's short of the,
Sir?
Short of there not being appropriation, that this would be, direct cost would be, and y'all can just go out and contract anywhere you want to get them an ID card, as long as they're paying for it. That's the wishes of the senator?
I think there's some miscommunication.
Would you like to come up here to the podium?
I think there was supposed to be a change to the language that would take the AOC out and therefore the physical aspect of it. And apparently that change didn't get made. I'm just reading an email that I got. So that might clear it up a little bit. I don't know. But
yes, sir. And that's why my earlier comment was I hope we were looking at I assumed we were looking at the most recent version of this, but it's made me question. So I'm wondering, Mr. Chairman, if there's another opportunity, can I come back with one that's cleaned up in the format of, or present a substitute in the format that?
You know, out of respect for my friend the senator, yes, sir, there will be another opportunity, and I'll make this opportunity to you tomorrow.
Thank you, Mr. Chairman. I appreciate it.
But I would also like to, just sort of give a few words to this. This doesn't need to be a cost to the taxpayers.
Yes, sir. And that was the intent to begin with. And
I mean, not that it's that big of a deal, but you know, in this day and time when we're talking about Second Amendment and carry rights, we have an abundance of citizens in this state that they feel that we have given certain special rights to certain people. Now, judges, I certainly understand that. They're a very special classification of people. But is their personal safety any more important than anybody else? We got legislators that we don't care. We don't have those special privileges. We've got other citizens across this state that aren't under the provisions of Code 130 and such as that. So, you know, when we're talking about this, if we could draw something in there, find an easier way to get them get them a permit, and and I think that's the direction we need to go. But if you will, if you'll contact the chair in the morning with a substitute, we might just have to have a meeting off the floor of the House tomorrow to get your bill moving.
Thank you, Mr. Chairman.
A little bit quicker.
Very grateful.
Thank you, Senator.
Yes, sir.
Judge, it's good to see you.
Good to see you, Mr. Chairman.
All right.
Thank you.
All right, we're going to delay action on this, as they say, ladder data. I want to bring to the all right, Senate Bill 320, Dr. Watson's bill. You should see in front of you, to the members, you should see in front of you the latest sub, which would be LC 410820S. All right. This bill, to the committee members, let me explain the bill. You know, from time to time, we use it as we get toward the end of the session. As we get to the end of the session, sometimes we use bills that have a same number. So we use them to do cleanup language from past years. This is one such bill. If you'd bear with me, I want to go over the changes of this bill. Last year, this committee, for the last 2 years, this committee was very familiar with a situation that we were dealing with taxis, limos, and the ride-sharing models. Passed out, certain changes were made in state law last year that didn't get fully clarified. If you look at Section 1, it clarifies that the Department of Motor Vehicle Safety over at DPS, that they're not to do inspections of the limo carriers. Y'all may remember that last year that they did a one-time fee, and they inspected limos in perpetuity to the end of time. And that was taken out last year. The Department of Public Safety would like that clarified, and that's what this does in Section 1. Section 2, this registers taxi services. Another clarification, it will that they'll have to register the taxi services at the Department of Public Safety. If you look at Section 3, Dr. Watson's original language, and I'm sure that the committee members probably had almost as many frantic phone calls and text messages and emails from sheriffs around the state that I did. There was a situation that existed of those foreigners who come into the state of Georgia for less than 30 days that they had on their driver's license. Georgia is the only state that required, as one of the other conditions, was an international driver's license. Now, go guess. And I've been here 20-something years, and you'd thought I should have known something of that, but it got so filed up that the senator's bill, what it did, it had like 5 or 6 different things that you had to put into that. After looking at all of that and discussing this with the Department of Driver Services and the other knowledgeable people, we realized that all we were doing was being arbitrary. Georgia was the only state in this country that required any of that. If you're a foreigner, if you're a snowbird, somebody from Canada or wherever, and you're here for 30 days or less, you got a driver's license. To make this quite simple for the law enforcement community, presumptively, they're going to check that driver's license. If there's an infraction, they're going to look at it. They're going to issue a bond, because they know that if they let them go, they ain't going to show back up most of the time, because we don't have reciprocity with foreign nations on traffic offenses. So there'll be a bond posted. But if you look at the language on lines 63 through 66, what we're saying is that they'll drive under the driver's license issued by the driver's licensing authority of a foreign country. A law enforcement officer may consult such person's passport or visa to verify the validity. So what we have is an officer of the law. If they stop someone, then they're going to basically look at it, and if they have a problem, they have suspicions of that license, then they can require to see their passport or their visa. Very simple process. You know, lawyers not our lawyer doesn't tend to write things in complicated terms, but somebody did, and we've cleaned that up. If you go to Section 4, this says that the Department of Driver Services, that people who get a for-hire attachment, the endorsement on their driver's license that we provided for last year, that they don't have to show insurance to the Department of Driver Services, because all they're doing is getting a license. They've got to have that, and they have to show that to the Department of Public Safety. This was the cleanup language we did. We also added one last section that cleans up a section at Driver Services. We passed a bill a year or so ago that said that the DUI schools that we have an interest in and that's regulated by the Department of Driver Services, that those schools cannot give away enticements. It diminishes the role of those DUI schools that provide those services. We have had some of y'all may remember the debate on that, but we had several of the schools who were offering freebies to people to come to that. And quite frankly, we chose not to allow that, but we didn't sort of left it into the air how it would be enforced. What we're saying in this, if you look on line 118, that in addition to the other penalties available at law, any person convicted of a second or subsequent offense under this subsection shall have his or her license revoked. So we've basically given the Department of Driver Services, if someone that gets caught and convicted of these enticements more than twice, then their license to operate a school would be revoked. Very light punishment. That's what the bill is about, and I'm going to open up the floor because we had some people who wanted to talk about this. Mr. Quigley.
Thank you, Chairman. The changes on the bill, especially narrowing down the number of IDs that can be considered or devices, is very helpful to us. That was one thing we're concerned about, was trying to train our personnel on the side of the road to look at 4 or 5 different types of ID. Of course, when we were dreaming of a single piece of ID, it'd be something issued maybe by the state that would enable us to know for a fact somebody does have a valid license. And I know there's a challenge with that. That's something maybe one day down the road maybe we could consider. It would make it a lot easier for a police officer or deputy at 3 o'clock in the morning on the side of the road to figure that kind of stuff out. But other than that, we appreciate you listening to us coming forward on this.
Thank you. Appreciate it. Mr. King.
Thank you very much, Mr. Chairman, members of the committee. My name is D.A. King. I originally signed up to speak on Senate Bill 320 because I wasn't sure that it was going to be changed from the version as passed by the Senate. I'm very grateful for the cleanup. I just stood up just now only with a very respectful suggestion in the form of a question. And that would be where the chairman cited the changes, line 63 through 66. The original purpose of requiring Georgia being the only state in the country that required what's called an IDP, or International Driving Permit, which is merely a translation into English of a non-citizen's home country driver's license. The reason for that move several years ago was because of confusion, I am told, on the part of law enforcement on the street not understanding the law. And that led to the original bill, and now we've come back full circle to correcting it. So I'm only asking if anyone else thinks it might be necessary at the end of line 66 to put the 2 words, if available, because there is no federal or state law that would require someone who is in this country as a non-citizen and non-resident to carry a visa or a passport. And my concern is, and maybe law enforcement can address it better than I can, but I am concerned that the original confusion that started the IDP will continue by removing it if we don't make it clear in the law to an officer that this non-citizen is no way required to carry his passport or his visa. So it's terrific, I think, if the officer can verify identity or or validity with the visa or passport, but not if anybody gets the impression that that is necessarily required to carry on one's person.
Any questions of Mr. King? Mr. Atwood.
Mr. King, thank you for being here. He's an
Yes,
old
sir.
friend.
Thank you.
And I thank you for your long-time service. I'm taking this way back. I was thinking we were required, if you were a foreign national here on your visa, to maintain your passport with you, but you're saying no, that's not current law, or help me with it. I'm not criticizing, I'm inquiring.
So my very recent research, Representative, is that while someone over the age of 17 or 18, I think, when they are a non-citizen coming to the country, they're required to carry proof that they lawfully entered the country.
Correct. Yeah.
I am told by people in Washington that that is a different document than the entry visa and or one's passport.
It's been so long ago that I frankly don't remember on that. So,
if I may, State Representative, again, I'm just up here like chicken soup. I don't think it will hurt to put those two words at the end of that sentence just to clear up any possible confusion.
I certainly wouldn't object to it, Mr. Chairman.
All right, let's get through. Let's see if we have anybody else that wants to address it. And you distinguished jurists down there, y'all can study it over. Oh, you're not a jurist yet. You're just still an attorney, Alex. By the way, did you get a pass on the magistrate's race? So you are, in fact, a jurist in waiting, indeed. Thank you, Mr. King.
Thank you, Mr. Chairman.
All right, let's see who else we have. Mr. Elmer Stansel.
Thank you, Mr. Chairman, members of the committee. I'm Elmer Stansel with the Georgia Department of Economic Development, and we're supportive of the Section 3 where it amends the IDP requirements. As you know, we have many international companies in this state and international visitors to this state, and they're very, very valuable to our economy. Last year, the international companies created over 9,000 jobs in our state and represented about $1.28 billion in investment. So thank you, Mr. Chairman, for bringing this forward to us. And like I said, we support the changes in Section 3.
You like this bill a whole lot better now than you did, don't you, Elmer?
Yes, sir.
It's a lot cleaner, isn't it?
Yes, sir.
I know y'all don't usually get this kind of treatment from most committees, do you? Any questions, Mr. Stansel? Thank you, Elmer.
Thank you, Mr. Chairman.
Mr. J. Morgan. Have we outlasted Mr. Morgan? I believe we have. All right. Any other? Does anyone else wish to be heard on this bill? All right. If not, to the committee members.
Thank you, Mr. Chairman. I apologize for being unprepared. I'm Mike Mitchell from the Department of Driver Services. Could I possibly look at a substitute copy?
No, sir.
Pretty please. No, I do want to, if I could, look at the language about the section on the DUI schools and offering the gratuities.
You'd like to step around here. We're fixing to pass an amendment to clean that up. Quite frankly, what it says is if there's anyone that is convicted of a second offense of the violation of the law that you're familiar with,
sure,
then y'all can suspend their license as a DUI school.
So it'd be based on a second conviction?
Based on a second conviction.
Okay, fair enough.
Thank you.
I can live with that.
All right. What's the will of the committee? First, I need a motion to pass. All right, we have a motion to pass. Do we hear a second? All right, we have a second. What's the pleasure of the committee now? Who wants to be recognized for an amendment? You are recognized.
Following line 67, AF license, comma, if available, period. And I've researched the law, and both of us are right.
All right. If you would.
I'll explain to the chair later.
All right. Alex, if you would, please state your motion again so we can get
Following line 67, after license, instead of the period, it would be comma, if available, period.
All right. Properly stated. We have a motion to amend the committee substitute. Any other questions from the members? All in favor say aye. Aye. Opposed? The ayes have it. Mr. Glanton, you're recognized.
Mr. Chairman, I'd like to offer an amendment beginning on line 118. In addition to all other penalties available at law, any person convicted of a second or subsequent offense under this subsection shall have his or her license, and I'm inserting to operate a driver's improvements clinic or DUI, alcohol, or drug use risk reduction program under this article revoked. And so, period.
You restate that. Restate that.
Beginning in line 118. Actually, let me just go down to line 120. What I want to insert after license, after the word license, to operate a driver's improvement clinic or DUI, alcohol, or drug use risk reduction program under this article revoked. And so we just add in those individuals that offer the driver improvement clinics to make sure that they're included as well.
All right. We have a motion. Do we have a second? Second. We have a motion and a second. Do we have any other questions about that amendment? If not, all in favor say aye. Aye. Opposed? And the ayes have it. Now we're back to the body of the bill. And this will all be done as a committee substitute. Any questions? If not, all in favor say aye. Opposed? And substitute committee sub to Senate Bill 320 goes forward. All right. Last but not least, we have Senate Bill 416. Mr. Hitchens, did you ever get a chance to look that bill over? Let me go through this as best I can. We've got some experts here. Let's see. All right, members of the committee, you should have in front of you LC 410811S. Y'all may remember at the last meeting, the Senate Majority Leader made an appearance. This is his bill, and this was his attempt to codify what is currently done by executive order. And this is the currently is GEMA, but it is the structure of the Homeland Security Act that deals with GSACs, the Fusion Center, and all of those. And as I said, currently that's done by executive order, a standing executive order from, and I'm not sure quite honestly which governor passed it, Colonel Hitchens. He was the director at one time.
The executive order has been changed several times depending upon who the Homeland Security was, what his background was.
See if I can cut you on over there. You on number 11 or 12?
That could be either. Be in the floor in a minute. The truth is the executive order has been changed several times in the past depending upon who the Homeland Security Director was and what their background was insofar as intelligence and dealing with legal issues. Some of the directors of GEMA and Homeland Security have come from the emergency management side and have never dealt with those types of issues previously. And when they did that, they typically put the GBI in charge of running GSAC and dealing with all the intelligence business. When I was there, I had both, but I think that's only happened twice. and that started back in 2002. So.
As I'd gone through the senators through this bill, if y'all would follow with me a little bit as best I can tell, Section 1, Section 2, Section 3, Section 4 are basically just renaming what's currently called GEMA. It just renames it the Georgia Emergency Management and Adds and Homeland Security Agency. Section 5 deals with the GBI, basically the GSAC Center, the Fusion Center, and if you look through this, it basically puts in what my concern was, that the GSAC would be under the control of the GBI director, not a Homeland Security director. My concern was that, GSAC, the GSAC is a criminal investigative function that needs to be under a law enforcement officer. Not at all times that whoever would be the director of Homeland Security, that person would be a professional law enforcement person. They could be military, but there's a lot of difference between military and being a law enforcement person. I've used the example that that'd be almost to me like saying the chairman of House Homeland Security and Public Safety would be qualified to run a law enforcement agency. Well, no, I'm not. I'm not a post-certified law enforcement person, and I don't need to, it wouldn't be in the best interest of the safety, even though I could carry a weapon without a permit at that point. But this, as best I can tell, clearly states that the director and that the GBI controls the law enforcement functions. The membership, when we get to line 135, basically sets forth the membership that's based under the executive order right now. When you get over to line 173, basically spells out that the GEMA director is responsible to the governor for carrying out the programs of the emergency management, Homeland Security in the state, and serves as a central reporting agent to the as a central reporting authority to the governor. And as best I can tell, as I go through this, near this, the biggest bulk of this paper is all about renaming the agency and adding Homeland Security. I mean, that's if y'all want to save a few pine trees, we could leave it at what it's currently called. But basically, it codifies what's currently being done. Let me open the floor to questions right now to the members of the committee. Any committee member have a question? If not, I'm going to open this up to probably more wizened and experienced people that may wish to testify out here. Mr. King, you're on the. I'm sorry, I do have a few. Colonel Hitchens.
Chairman, it may be better.
I'm sorry.
I was going to ask a question about how long, and I know the colonel here may know, but how long has so we already have indeed a Georgia Information Sharing and Analysis Center, correct? How long have we had the center, and so it's currently under Homeland Security?
October 2002. It's always come under Homeland Security, and the director of the GBI has essentially always been in charge of it. And I've got some articles here from Oregon where they did some digital research without without proper authority, and there's a real problem out there now. The American Civil Liberties Union suing their Fusion Center and the Oregon State Police, and it's just a mess because somebody did something that they really didn't know what they were doing.
So, Colonel, we've had this has been under Homeland Security, but the GBI has been really managing this center anyway, in spite of the location in the bureaucracy.
That's correct. They've
Okay,
always
gotcha.
had the agent in charge over there who was responsible for the Fusion Center.
So this is just putting it where, this is really codifying what we are currently doing and have been doing since 2002.
That's correct. You know, we
Okay.
have, as I said previously, we have had a couple of directors that came from the emergency management field that had never been involved in law enforcement, and they didn't play much of a role in what occurred at the Fusion Center. But it's gone back and forth.
Thank you. Thank you.
But the GBI has always been in charge of it.
As it should be.
Right.
All right. Any other questions of any of the committee members? Mr. King?
Mr. Chairman, my reason for staying at the Capitol until now was directly related to the answer that was just discussed here. My concerns and questions were just answered, and I'm going home. Thank you very much.
DA, I want to thank you for waiting around with us. Do we have anyone here that wishes to testify? Do we have anyone from, first off, do we have anyone from the governor's office? Harris, I don't think you're qualified. I don't think they sent you over here for this, did they? Unless they're fixing to move you over to head GEMA. No? Do we have anybody from the governor's office that wishes to testify? All right. I see Scott from the GBI. Do we have anyone from GEMA here? Yes, sir. Well, why don't you come on up? You're over there hiding pretty. You're hiding pretty good behind that post. If you would come on over here and to the podium and identify yourself to us, please. And thank you for being here.
Yes, sir. I'm Lauren Curry. I'm Chief of Staff at the Georgia Emergency Management Agency.
Good.
Be happy to take any questions that I can help, or Scott's here as well between the two of us.
What is your title again?
Chief of Staff.
Chief of Staff. So
Yes,
you work for Director Butterworth.
Yes, sir.
All right. Can you lend any of your thoughts about this bill, about the necessity of codifying this bill, and things going to work better this way or not, or?
I think the desire was to take what's in the current executive order, which is a 2010 executive order. That was the last time. And much of this language has come straight from that executive order. So this does codify what we're doing with GSAC and how we're working with GBI currently. It does also include the name change.
And y'all have a good relationship with the GBI right now?
Yes, sir.
And do you foresee that this is going to stay that way?
Absolutely.
All right. Any questions from the committee members? If you would just sort of hang around
Yes,
just
sir.
a little bit. And, all right. Scott, could you maybe come up and see if...
Yeah, thank you, Chairman. Of course, I'm not prepared to testify, but I am prepared to answer any questions that you may have. Actually, GSAC was created in 2001 and was actually by Executive Order 2003 and then again in 2010. And I know that from being assigned to GSAC during its inception, during its creation under the Barnes administration. For all practical purposes, it's an intelligence task force comprised of state, local, federal agencies to include emergency management and private sector to a certain extent. And all those levels work in a task force environment based on a need to know, with the primary function of protecting the citizens of the state of Georgia. And since 2001, there's been a learning curve. It's developed into a closer and better working relationship with FBI and U.S. Department of Homeland Security. An important piece to remember here is this was created at a state level. This was before U.S. Department of Homeland Security was even thought about. It was a function that needed to happen, and the leadership at that time thought it was a good idea to make this happen, and it has evolved to what it is today. 2012, GSAC was recognized as the Fusion Center of the Year for the entire country. There are currently 77 Fusion Centers across the country. Each state has a primary Fusion Center that is accountable to the governor's office. GSAC is a model for the entire country. A lot of other Fusion Centers have followed the direction that that we've done in Georgia, and a lot of that has to do with just the longevity, the trial and error, the status of where we are today.
Any questions? I might ask a question. You've seen the sub. Are y'all convinced as a law enforcement professional that this is tight enough language that it unequivocally says that the GBI will be in charge of GSACs and those investigative duties?
Yeah, it's specific to I think it's Section 5 that we were asked to take a look at from the governor's office and in conjunction with the Georgia Emergency Management Agency. We went through the language. It was important to us that the Fusion Center responsibilities, roles, liabilities, everything associated with that was a GBI function. That has been accomplished in that Section 5. Of course, I'm not a lawyer. I don't know the finer details of how all those things work, but a meeting was held between the GBI director and the GEMA Homeland Security director to work out those issues specific to that Section 35. As far as the other sections, yeah, that was worked through as well. That's not necessarily a GBI title that we necessarily focus on, but we were part of those discussions.
All right. Any questions from the members? Thank you, Scott.
Thank you, sir.
I just have to have this question to the lady from the chief of staff from GEMA. You know, through over half of this bill, probably 2/3 of this bill was consumed with just basically renaming GEMA by adding Homeland Security in there. You got any idea what was the need? Because aren't y'all going to have to change branding and such like that?
We would. Right now in code, we're known as the Georgia Emergency Management Agency. When the Office of Homeland Security was folded in, it became Georgia Emergency Management Agency, Office of Homeland Security. So when you see our letterhead, we have both titles, which is a mouthful at best when you're trying to explain the Homeland Security mission. So this was simply a way to say emergency management and Homeland Security. It's obviously an important piece of what we do, and it often gets kind of as a tagline, and the Office of Homeland Security. So this is it. Right now, we refer to ourselves as the Georgia Emergency Management Agency / Homeland Security or / Office of Homeland Security. So this is simply an easier name that has both of our missions equal footing.
Going to create hundreds of thousands of dollars of new expenses unfunded.
I can assure you, as the person that manages public affairs as well, we don't have hundreds of thousands for any kind of branding. So, no. We will certainly have no intent. Most of our stuff is electronic, and it would be phased in. So I don't think I do not expect any major expense at all.
All right. Any questions? If not, what's the will of the committee? We have a motion. We have a second?
Second.
We have a motion and a second. Anyone else wish to be heard on this matter? Any further questions from any of the committees? If not, all in favor say aye. Aye. Opposed? The ayes have it. Ladies and gentlemen, thank y'all for hanging around such a late hour. Thank the committee members. And we'll probably call a meeting off the floor tomorrow to take another look at that.